that a portfolio chairperson ought to have been well aware by March of 2016 that a portfolio committee did indeed have the power to pursue this type of inquiry if its members collectively decided to do so?
Chair, it's a definite yes. When members are sworn in, they not only get a constitution, they also get a copy of the rules. So, even an ordinary member who is not a chairperson would have known that it was and it still is within the powers of the committee to investigate.
Now, I want to take you to another similar document at about the same time. And you go to page 727. Just to remind you, the last document we looked at was dated the 15th of August 2017, and this document, on its face, is dated the 23rd of August 2017. So it's a week later. And it's on much the same issue. Subject: opinion on steps to be taken by a portfolio committee in investigating allegations of state capture in organs of state. And then if I take you to paragraph 2 at page 729, the legal question to be considered is, A, in terms of the law and rules of the National Assembly, what steps may be taken by a portfolio committee of the National Assembly to conduct oversight over organs of state? B, what other issue must the committee take into consideration in dealing with the referral? And the advice, the chair will read it in due course at his leisure, the advice essentially is, you will adopt whatever procedure you think to be most appropriate in your wisdom. As long as you, as the committee, keep control over the process, that's your rights. Now, that, I assume from your earlier evidence, Ms. Modise, is precisely what any chairperson, and frankly any member of any portfolio, should have understood already. I see you nod, if you can just say yes into the record.
Yes, Chair.
Okay. Now, against that background, because what we're now looking at, if we give the ruling party the benefit of the doubt, and to say, well, in June of 2017, they finally woke up through the chair, through the speaker, through the chair of chairs, through this announcement issued in the press in response to the Gupta leaks. They said, there does now need to be an urgent investigation in 4 committees on these allegations in relation to state capture. Now let's go back and look at how that is implemented. We were at Annexure O, we were at pages 499 to 515. Let me just see if I've completed that. Yes, can I take you perhaps through to 510? I think that's where we digressed.
Have the page.
You will recall that I drew your attention at page 510 to the 6th of March 2018, when Mr. Gagaba finally appears before the committee. And then this report summarizes how things developed, and you'll see at page 511 that, and this is Roman numerals 14, in a meeting of the PCHA on the 27th of March 2018, the committee decided to broaden the scope of the investigation into the broader process of naturalization of the entire Gupta family. I can leave it at that. And then you will see, if you turn to the next page, page 5, or if you go to page 513, on the 11th of September, the committee finalized its preparations for the inquiry. On the 12th of September, inquiry day 1. So we finally start this inquiry. And we see 13th September, inquiry day 2, 9th of October, inquiry day 3, 12th of March, inquiry day 4, 13th of March, discussion and adoption of the final report. And that's the very report we are now reading. And if we leave out a lot of the detail, which will be familiar to this commission for other reasons, and we go through to really the conclusion of this, or the concluding parts of this report, if we maybe start at page 555.
555.
555.
I have it.
You will see there's a section headed Observation. This is after summarizing what's happened at all the various days of the inquiry. Now we start coming to, as it were, the conclusions. And they make what they call observations. And the very first observation, they say this: based on the evidence provided to the committee, despite the limitations and gaps in information mentioned in section 9, the observations of the inquiry are the following. 1. The committee acknowledged that the initial applications for naturalisation by A.J. Gupta and family were dealt with by the department as a family application and were correctly rejected, because that was the nub of the issue. What had happened subsequent to that is the minister had overturned that decision. And what this committee is finally saying is they were correctly rejected. And then point 3 on the next page, the application for early naturalisation approved by former Minister Gupta of A.J. Gupta's family was incorrect. That's one of their observations. And then they comment adversely on various senior officials. And then they make some recommendations. And the recommendations include amending certain legislative provisions, and that criminal charges should be laid against Ashu Chawla and members of the Gupta family relating to false information submitted in their early naturalisation applications. So what I want to put to you is this. At the end of the day, what appears at face value to be a credible report was produced, but that the delay in producing it was completely inconsistent with the mandate, which was in the middle of June of 2017, urgently to investigate and report back to Parliament. It's quite clear that that did not happen. Do you agree?
I agree.
Now, I'm not going to spend any time on the Portfolio Committee on Public Enterprises, because we all know what happened in this committee. This commission has heard a lot of evidence on that. In short, there was a decision starting in May 2017 to conduct an inquiry. It broadened and then narrowed down to ESCOM. It was a proper inquiry. It produced a report. The report was furnished to this commission. But I would like to look at the other committees. The Transport Committee was mandated to look at allegations in relation to PRASA. Is that correct?
That is correct.
And I think if we go to your own joint submission, paragraph 46, fairly early in Mandel 6, is your page number. It's at page 19. Now, I'm attributing no personal fault to you, Ms. Modise, but what I'm going to be putting to you is what is stated here is not entirely accurate. So let's just look at it. Subsequent to the letter from the House Chairperson, the committee issued a report documenting its past oversight activities over the Department of Transport and PRASA during the period 2014 to 2017. Let's just pause there. This request is made in the middle of 2017. The report detailed engagements regarding the management and operations of the entity, which also included various references to investigations into financial misconduct alleged within the entity, and then the sentence that I take issue with. Specifically, the committee submitted this report in lieu of a formal inquiry and did not generate any new insights. In other words, the suggestion that's made in your submission is that the response from the Transport Committee is, we've done all that, there's no need for it, we've investigated adequately thus far. Now, let's just leave that there. I won't ask you a question about it, because I want to put something else to you. If I take you now to page 736 in the same bundle.
Seven.
736. Well, perhaps that's not fair. I think it is fair. You have it. It's a letter dated the 16th of March 2018. So the impression created by your joint submission is that really there was the response of the Transport Committee is that there's no need for an investigation because of our prior oversight. But if you read this letter of the 16th of March 2018, I want to put to you that it shows that that can't possibly be correct. Not least because if you go to page 738, second paragraph, you will see in its meeting of 20 February 2018, the committee resolved to institute an investigation into the matters of concerns regarding the various stakeholders, etc. And then they talk about, in the second last paragraph, the terms of reference having been adopted. This committee actually did resolve, but only resolved in February and March of 2018 to carry out an investigation of precisely the sort that was directed by Chairperson Froelich. And what's more, I want to just explain to you, we have had evidence from both Mr. De Freitas, the DA member, Manny De Freitas, of attempts that he made in this committee to have these investigations take place. And we've had Ms. Magadzi, who has responded, and I think she herself accepted in her evidence that the committee had been remiss in failing to investigate as they should have. So all I want to really put to you is, can you accept that when your joint submission says that really there was, from the response from the committee, no need for an investigation and it died there, your evidence is just mistaken because there's a whole lot of detail which you were presumably unaware of?
Chair, I have no option but to accept what you are saying. But remember that we also said in our joint submission, and I noticed that this letter that says now we are investigating comes from the same member, Magazi.
Yes, indeed.
Who you are telling me had earlier on said that they were remiss in not investigating. The chairperson of the NCOP and I stated up front that where we have not personally dealt with matters, we have been informed that things are right and we accept that they are right and true because we could not have known every little...
Yes. I understand that. I want to give you my personal, unequivocal assurance that I understand the spirit in which this evidence is given. You were not even then the speaker, much less personally involved, but you are now the speaker. You rely on documents that have been presented to you. You've made clear in your submission that not everything is in your personal knowledge. You rely on documents which are attached, but nonetheless, it's my duty, if I see something that seems to be wrong in the document, to point that out. Otherwise, what you've said might be taken as being clearly correct when there's reason to suspect that it may not be correct.
Chairperson, I'm grateful that the disconnect is pointed out to us.
Yes.
That means we must be more thorough next time.
Yeah. No, that's fine.
Now, I want to just move on and deal quite briefly with a few other features of your joint submission. So can I take you to paragraph 54, which is at page 21.
I have it.
Now, I just want to put this in context. Quite understandably, what your joint submission does, after referring to the Froelich letter and the press release that we've looked at, you look at the 4 committees that were identified by him, but then you move on and say that it's also important for the Commission to be aware of things that happened in other committees beyond those 4. And one of those that you draw attention to is the Portfolio Committee on Police. And you make the point in paragraph 54, during the 5th Parliament, the Portfolio Committee on Police, in addition to its business, held 6 meetings on state capture. These meetings considered progress reports by the Directorate of Priority Crime Investigation, DPCI, on high-profile cases under investigation, including state capture. And you then itemize those in the paragraphs that follow. You refer to what happened on the 28th of February 2018, the 7th of March 2018, and so forth through to March of 2019. And I have no reason to doubt that those summaries are reasonable summaries. But the point I want to put to you is, again, this has to be seen in context, does it not? Because this is commencing once the new president has taken office, and it is not showing us what this committee, the police committee, were doing in the heat of the era in which these allegations were being made. And I want to put you, for example, just to illustrate the problem, that there has been a lot of evidence before this commission in relation to Bosasa. In relation to Bosasa, the evidence is that in 2010 or perhaps 2011, the SIU had investigated these allegations. It was publicly made clear that these allegations had been reported, that the report had been given to the National Prosecuting Authority, perhaps referred for further investigation. 8, 9, 10 years later, we are not seeing precisely the sort of response that you are highlighting here as to what happened from February 2018 onwards. We see precisely the opposite. That although this report is in the public, not in the public domain, but although the members of Parliament are fully aware that the SIU believes there is substance in these very serious allegations of extensive corruption, nobody is saying, what's happened to this prosecution, or if they are, not with any diligence or follow-through. You want to comment on that at all?
It's difficult to get into the head of something that happened in 2010 and try and make an intelligence response. I can't even tell you what I was doing in 2010, whether I had heard of this or not. But I will go back to my response that perhaps we need to make better use of the legacy reports from portfolio committees to carry on. Because between 2010, you have an election in 2014. I'm not even sure whether the membership of the committee is still the same. But what we do have being constant is the administration. And that is why I went on earlier on to say perhaps that's where we need to make the link. So that as you have the new membership, the new committee chair, there is orientation and there is a discussion about the resuscitation of business. Because if you have a new committee and nobody brings to their attention that there are, by the way, there are issues that were hanging there, they will continue and discover new things. And if the executive or the administrative heads are still the same, who says they would be keen to reopen what they perhaps don't want to reopen?
Yes.
So we can only charge ourselves as Parliament to say we need to be more alert to this. We need to pay more attention to the last reports of committees and the revival of committee work reports.
Yes, but I accept your point. But your point illustrates the problem of what happened in fact rather than what should have happened in theory. Because the legacy report in 2009 raised this as a matter of extreme concern. The SIU report is issued shortly into the period of the next portfolio committee. When it issues its legacy report in 2014, not even mentioned. But notwithstanding that, it remains reported on in the press, and nothing happens. Now, I suppose this is really not a fair question to put to you because you're not directly involved in this. But the principle we can discuss. And the principle is that I'm sure you would accept that it is incumbent on responsible members of Parliament within their respective portfolios, when serious allegations of corruption have been made known to them, and when it's been reported to them that the SIU thinks there's merit in these allegations, to satisfy itself by repeated questioning and follow-up that these allegations have been appropriately disposed of. You would accept that principle?
I will accept that principle.
One would obviously not want to dictate to Parliament how it should deal with its internal matters, but it may well be that the House chairperson responsible for portfolio committees should make it his business or her business if the gender changes. Make it his or her business to know the legacy reports of the various portfolio committees, particularly what was identified as needing further attention by the incoming committee, but that also once the new committee has looked at the legacy report and identified matters that they want to take forward, which came from the previous Parliament, that maybe they should share that information with him or her. So there would be somebody who has a globular picture of what's taken. But that might just be something. It may be that it's not necessary, but one would think somebody who coordinates some of these things, and maybe if something is left out, is not pursued, that seems quite important, then ask questions to say, but this is important, why are you not taking it further? I don't know what you think that might help.
It will help. We have been looking at the capacity of Parliament. And that seems to me it falls right there. Because if you can't retain not only the bad, also the good practices, because as you empower members, you must be able to pull out the good examples and the bad examples. And so for me, it comes back into how do you ensure that things don't fall between the cracks. So in that regard, I would not even say that leave the blame with the chair of committees. Take it right up to us who are responsible. Speaker, do something about that. Make sure that you track, you know where things are. And that is a commitment I can make, Chair.
Thank you.
Thank you. If I could now take you to page 16, please.
16.
16. This is when you, after having introduced the topic of what are the duties, what is oversight, what is accountability, you start dealing with the substance of your submission. And you make the point in paragraph 32. You say the Portfolio Committee on Justice and Correctional Services raised its concern about the delay in establishing the terms of reference for the Commission. That is this very Commission before which you are now testifying. Now, I just want to pause and consider this a little. Because in October of 2016, the Public Protector released her State of Capture report. There was some initial controversy about whether it was going to be made public. There was some threatened or actual litigation. But by November of 2016, as your supplementary submission correctly points out, it was in the hands of the Speaker of the National Assembly, and if I'm not mistaken, I think it may well even have been tabled before the National Assembly. Is that correct so far?
Yes, it is correct.
Now, the recommendation by the Public Protector that there should be a judicial commission of inquiry whilst it has its advantages, and we are seeing many of the advantages now, it also could perhaps have been used as a pretext by some not to do what they should have done. So there was a view that was expressed by some that this question, all these allegations, should simply be left from the time of the October 2016 State of Capture report through the whole of 2017 into 2018. It's not Parliament's business. Let the Commission be appointed. Now, from what I've been hearing in your evidence this morning, you would not be of that school. You would be of the school that Parliament must do Parliament's job. And if Parliament is aware of allegations of relevance, they have the power and should exercise the power to investigate, obviously seeking not necessarily to duplicate in two forums work being done simultaneously in both. But the principle that the existence of the recommendation for a judicial inquiry is not a good reason for Parliament not to do its own work. Do you agree with that principle?
I agree that within the powers and responsibilities of Parliament, any matter could have been investigated. If the Judicial Commission was then established, then all the committees would have needed to do is to hand over the work that they had done so that there is no duplication.
Yes, and I don't think that anybody here takes any issue with that. But what you then say in paragraph 32, and I'm not saying it's wrong, you say the Portfolio Committee on Justice and Correctional Services raised its concern about the delay in establishing the terms of reference for the Commission. But that was one of the issues on which, in my request for further information, I said when. You answered that in your supplementary submission, and we find the nub of the answer at page 412. This is one of the additional documents that you furnished. And it exactly bears out what you said. But of course, as ever, timing is important. And we see that this is a report dated the 24th of January 2018. This is after the election of a new African National Congress president. This is a whole new political world we're in. Parliament's Portfolio Committee on Justice and Correctional Services today expressed its grave concerns about the delay in releasing the terms of reference with regard to the Commission of Inquiry into State Capture. Committee Chairperson Dr. Matoli Machecha said that the President must issue the terms of reference as a matter of urgency, and it must be based on the remedial action of the Public Protector's report on the State of Capture. This matter cannot be delayed any further. Now, I don't think anybody would criticize Machecha for saying that. But my question to you is whether you think that the pending possibility of this commission of inquiry actually served as an excuse that was latched onto by some for not doing what they should have done in Parliament in relation to the issues, very serious issues, that emerged from the Public Protector's State of Capture report.
Chair, I'm not sure how to answer this question. I have to now creep into people's minds and try and explain why. Remember, Chair, that Parliament does not have the powers to establish a judicial commission.
Yes.
They can just make noise and urge the president to do that.
Yeah, you can put pressure.
They can put pressure on the president to please hurry up and do this thing. In the meantime, as I said earlier on, nothing would deter a committee to do the little bit that they can.
Yes. And the only part of your answer I take issue with is the word little bit. Because those committees have a power of subpoena, they have a power to compel people to come and answer questions, and they have expertise in their own respective domains. So in fact, it's a significant power that they have.
They have big powers. I used to boast about those powers. But the little bit I'm talking about is that at that time, most of the information that is now in the public domain and within the reach of Parliament was not there. That most of the issues which we are now confronting, and sometimes we still get shocked. There was the hearing on the Intelligence Committee, and we sat and held on to our chairs because there are things that the rest of committees would not know, and therefore the little I refer to is what I know and what is before my committee I must pursue, so that each and every committee can then, and that is why Mr. Frolik was right in writing to those committees that were identifiable as being affected by the state being captured, to say, hey, hurry up and investigate.
Yes.
Because in that way, he thought, we as Parliament, that perhaps we would be able to get to understand exactly what has happened, what is the extent of this thing. Up to that time, we had never heard of a member of Parliament who had received any money relating to doing or not doing their job.
But what you had heard long before that time, this is what I explored with Mr. Montashe last week, as early as February of 2011, reports in the press alleging undue influence by the Gupta family, not only over the president, but over the appointment of cabinet ministers, over the appointment of SOE boards and chairs. And Mr. Montashe's response was, well, we had no evidence to confirm that. But then in an NEC meeting in that very year, a minister says, well, I can confirm it. I was one of the people who was told by the Guptas, and nothing happens. Now, with the benefit of hindsight, and this is obviously not a matter of your personal accountability, we're looking at the system. With the benefit of hindsight, would you accept that Parliament could and should have investigated a lot more vigorously, a lot earlier?
Chair, I'm on record as saying Parliament must investigate any matter related to their portfolios as portfolios. It is difficult sometimes when you investigate everything that you read about in the newspapers. Because I have read stories about myself starting to read, and only when I saw my name I then became aware, oh, they're talking about me. Information that I didn't know, things I'm supposed to know or have done that I do not know. So when you get into that space, you realize that Parliament, and that is why when a member stands up in the House and makes an allegation that is serious, that can affect the standing, the conduct of the member, we immediately say, substantiate. so that we actually deal with facts. Now, if a member of the ANC sits in the NEC of the ANC and says, yes, the Guptas, how does Parliament transport that into a portfolio committee?
Well, that was going to be my question to you, because either it can or it can't, but I think the answer must be it can. So if the allegation is that there is undue influence affecting ultimately the control of state-owned entities, then that seems at face value to fall within the remit of the Portfolio Committee on Public Enterprises. And how can they deal with that? They can summon that very minister, and they can summon the persons whom he accuses, and they can examine whether there's any truth or not in it. Do you agree with that?
I have to agree.
I guess that is, Mr. Freund, if they get to know what happened in the NEC.
Oh, absolutely.
Yeah.
Absolutely. But what was alleged to have happened in the NEC was also reported in the press in that year. Now, they wouldn't know if those press reports are true, but at least it gives you the basis to ask the people about whom the press reports have been made, did you say that? If so, please tell us the details. If somebody else denies it, come and tell us your story and we investigate. That's really the problem, that for year after year after year, these allegations that I as a citizen who had nothing to do with Parliament or politics, I was fully aware of, it seems to me Parliament turned a blind eye to and just did not investigate. Now, I don't know if you wish to comment on that.
Yeah, it is difficult to comment on this, because the question I put is, how do you take a discussion which happens at a political party into Parliament? Supposing they had done it, Chairperson, would that committee, particular committee, not have been accused of taking factional issues of the ANC into Parliament, and therefore? So sometimes you need to put yourself into the political space and try and understand where were they coming from. If the minister had made that statement in a portfolio committee, in the House, definitely we would have had to say, but this. It's difficult with hindsight to say, but they were wrong here. Is it a matter they could have investigated? Yes, they can investigate anything, anytime. Why didn't they do it at that time? I really don't know.
Yeah.
Now, I understand that you were not party to that. You were not in that committee. It was not a decision that you personally had to deal with. But I'm trying to explore the question of principle here. And the question of principle really is this. If there are allegations in the public domain, not only in the press, well, I mean, they're made in the press, but they are reporting matters which, if true, are a very considerable concern, that I'm sure you would agree those should be investigated. So the question then becomes, well, was there sufficient material in the public domain to justify an investigation? And Mr. Mantashe told us last week that by 2013, the Integrity Committee of the African National Congress was urging the president to stand down in relation to these very sorts of issues. If it was known to them, surely it was known to enough people in the ANC that if the president didn't step down, if the president disputed these allegations, which was absolutely his right, there was a duty to inquire through Parliament. I emphasize, through Parliament, not merely through the structure.